Congresswoman Crockett, how do you justify this law under the Voting Rights Act when it disproportionately affects minority voters? Justice Breyer's voice cut through the tense courtroom like a blade. Every pair of eyes locked on the young Congresswoman at the podium, her calm presence belying the storm of history she was about to confront. The law's stated goal of efficiency masks a discriminatory impact. Crockett began, her tone steady, eyes scanning the room as if daring the justices to challenge her. 93% of polling closures occurred in districts where Black and Hispanic voters are the majority. Meanwhile, affluent white areas saw no reductions. Some even gained additional locations. Justice Thomas raised an eyebrow. But Congresswoman, the state claims this was purely budget-driven. Isn't that a legitimate reason? If budget were the true motivation, we'd see proportional closures across the state, Crockett countered without hesitation. Instead, the closures save a mere 0.3% of election administration costs while disenfranchising 27% of registered voters in minority neighborhoods. The precision of her figures, cited without consulting notes, made a ripple of astonishment pass through the room. Justice Barrett leaned forward. Even if we accept the burden, the Fifth Circuit found the state's interest compelling under Anderson-Burdick balancing. Why should we overturn their conclusion? Crockett's expression didn't falter. Because the Fifth Circuit ignored empirical evidence. Crawford versus Marion County demands that burdens on voters be measured realistically. Here, we have a GPS study. An East Houston resident, age 72, must spend 3 hours on public transportation each way to vote. This isn't a mere inconvenience. It's a near impossible barrier. She tapped her small device, projecting the tortuous route on the courtroom wall. Gasps and murmurs rippled through the gallery. Justice Alito leaned back, skeptical. A single example hardly proves a systemic problem. Not a single example, Crockett replied, eyes steady. We conducted a comprehensive analysis across all affected precincts. Exhibit 47 demonstrates that 62% of impacted voters would face commutes over 2 hours. For hourly workers, caregivers, and the elderly, that is a severe, unconstitutional burden ignored by the Fifth Circuit. The courtroom grew tense. Every justice leaned in, some skeptical, others intrigued. Justice Breyer, who had been unusually quiet, finally spoke, his voice measured. Congresswoman, imagine a state law assigning voters to locations based on the last digit of their Social Security number. Suppose 90% of Black voters are assigned to a distant site. No racial language is used. Would that violate the Constitution? Crockett paused, taking a breath, then nodded. Yes, Justice Breyer. That mirrors Yika versus Hopkins. A facially neutral law that produces a racially disparate outcome can violate equal protection. The Texas law uses proxies, past turnout, tax revenue, but the effect is the same. Minority voters are systematically burdened. She shifted seamlessly, citing Gillian versus Lightfoot, where municipal boundaries were manipulated to exclude Black voters despite ostensibly neutral criteria. This court recognizes that both blatant and subtle methods of discrimination are unconstitutional. Justice Breyer leaned forward, visibly intrigued. But how do we know the state's justification isn't genuine, rather than pretextual? Because we have their own evidence, Crockett said, flipping through her binder and producing a single sheet. A regression analysis by the state statisticians shows a 0.91 correlation between their efficiency formula and minority population percentages. Dr. James Rogers, who authored the formula, testified he was instructed to achieve these demographic outcomes without mentioning race. The courtroom murmured, a statistical correlation that high was damning. Justice Breyer nodded slowly, clearly impressed. And the remedy you propose? We seek targeted relief, Crockett answered. Invalidate the formula and require any future closures to undergo federal preclearance, ensuring compliance with the Voting Rights Act. Similar oversight has precedent in Shelby County versus Holder for jurisdictions demonstrating current discrimination. The silence that followed was electric. Journalists scribbled furiously, clerks whispered in corners, and the justices exchanged glances that spoke volumes. For the first time in decades, the highest court had witnessed an advocate command the room not through theatrics, but through unassailable evidence, relentless logic, and moral clarity. Justice Breyer's usually impassive face softened into a rare, approving nod. The old guard and the new generation of American leadership had met in the heart of the Supreme Court, and the nation watched, breathless, as the scales of justice seemed to tilt toward fairness and equality. Crockett's final seconds were slipping away, but she stood resolute, her voice unwavering. The right to vote is the foundation of every other right. When barriers are constructed, artificial obstacles that prevent citizens from exercising this right, our democracy itself falters. The evidence before this court demonstrates that Texas's law didn't create such obstacles by accident. It was deliberate. We ask this court to act as the guardian of fundamental rights and strike this law down. The red light flashed, signaling her time had expired. She carefully gathered her notes. The courtroom remained unusually still, charged with an almost reverential tension. Everyone present recognized they had witnessed something historic, a masterclass in constitutional advocacy that would echo for decades. Then came a moment that would become the stuff of law school legend. Justice Breyer, known for his formal reserve and relentless questioning, leaned back in his chair and looked directly at Crockett. His voice cut through the silence. "Congresswoman Crockett," he said, measured and deliberate. "In my 27 years on this bench, I have never heard an argument presented with such clarity and constitutional precision." The chamber seemed to exhale as the weight of his words sank in. Praise like this during oral arguments was virtually unheard of. Journalists froze mid-scribble. Law clerks exchanged wide-eyed looks. Even the Texas Solicitor General, poised for his turn, seemed caught off guard. Crockett paused, momentarily surprised by the unprecedented recognition, then smiled faintly and said, "Thank you, Justice Breyer. I appreciate your words. But the focus isn't on my argument. It's on the 8 million Texans who now face nearly insurmountable barriers to exercising their most fundamental right. Their voices, not mine, deserve the court's protection." A subtle nod from Chief Justice Roberts, a barely perceptible glance from Justice Kagan, and the murmur of acknowledgement across the chamber underscored the shift. Justice Breyer leaned forward. "Indeed, Congresswoman. On that note, one more question. You've established a strong correlation between the state's formula and the racial composition of affected areas. But correlation is not causation. What specific evidence shows the Texas legislature was aware of the disproportionate impact before enacting the law?" Crockett didn't flinch. She raised a finger. "First, the legislative record includes statements from Senator Williams, the bill's sponsor, dismissing concerns about minority voters. He said if they wanted to vote, they'd find a way. Second, emails between the governor's office and legislative leaders explicitly calculate how many Democratic votes would be neutralized by the closure formula. Third, a former legislative aide testified about closed-door meetings where lawmakers discussed using ostensibly neutral factors as proxies for race to avoid constitutional scrutiny. She lowered her hand, letting the weight of the evidence settle. Taken together, these documents, emails, and testimony establish that the legislature knew the effect of this law and intended it, while disguising its purpose behind neutral language. The Texas Solicitor General jumped to his feet. "Your Honor, I must object to this characterization. None of this was deemed credible by the Fifth Circuit." Chief Justice Roberts' gaze was steady. "Counsel, this is not a trial court. Objections will be addressed in argument. Please proceed with your presentation when it is your turn." The Solicitor General sank back into his chair, visibly rattled, a rare crack in his composure at the Supreme Court. Justice Breyer nodded toward Crockett. "You may take your seat, Congresswoman." She returned to counsel table, calm and collected. Justice Kagan whispered to Justice Stahmeyer, who nodded subtly. Justice Barrett, leafing through the joint appendix, checked the documents Crockett had cited. The momentum had clearly shifted. Chief Justice Roberts addressed the Solicitor General. "Regarding the emails cited by Congresswoman Crockett, are you disputing their authenticity or the acknowledgement that they show partisan and racial impact?" The Solicitor General faltered. "Your Honor, the emails discuss partisan outcomes, not race. There's nothing unconstitutional about considering political implications." Justice Kagan interjected. "Yet the emails themselves state that 90% of the impact will be on minority communities. Isn't that a direct acknowledgement of racial consequences?" The Solicitor General hesitated, then fumbled. that statement is taken out of context. The full email shows. Kagan held up the page. No further context follows. In fact, the next line says, and I quote, "Best of all, we can defend this on cost-saving grounds if challenged." Color drained from the Solicitor General's face. The justices had read the record more thoroughly than he anticipated. Justice Thomas, rarely vocal, leaned in. "Counsel, under Section 2, the critical question isn't whether the state created conditions, but whether the system interacts with those conditions to disenfranchise voters. How do you respond?" As questioning continued, it became clear that Crockett's careful preparation had transformed the session. Even justices inclined to sympathy for the state were probing with unprecedented scrutiny. Justice Breyer delivered the final, decisive question. Is it your position that a law which predictably and demonstrably suppresses minority voting can be constitutional so long as it uses racially neutral language? The Solicitor General struggled to thread the needle. Your Honor, a law with a legitimate government purpose, applied through neutral criteria, is constitutional unless there is clear evidence of discriminatory intent. And what of the legislative aide's testimony regarding closed-door meetings? Breyer pressed. The Fifth Circuit dismissed it as unlikely. On what grounds? The district court judge found the witness highly credible, Crockett added firmly. The Fifth Circuit simply disregarded the testimony without explanation. When the Solicitor General's time expired, Chief Justice Roberts turned to Crockett. You have 4 minutes for rebuttal. She rose, taking a slow breath. Thank you, Chief Justice. The right to vote is fundamental because it preserves all other rights. When deliberate barriers are erected, particularly against communities of color, our democracy itself is diminished. The emails, testimony, and statistical analyses all point to a conscious effort to reduce minority participation while maintaining plausible deniability. This case asks the court to examine not just polling places in Texas, but whether our Constitution tolerates sophisticated forms of discrimination that hide behind neutral language. The drafters of the 14th and 15th Amendments and the Voting Rights Act recognized that discrimination evolves. They entrusted this court to see beyond superficial neutrality to safeguard the right to vote. We ask you to fulfill that solemn responsibility today. She returned to her seat. Silence lingered in the chamber, profound and reflective. Even those opposed to her position recognized the extraordinary nature of her performance. Chief Justice Roberts closed the session. The case was submitted. Outside the courtroom, the effect was immediate. Reporters, supporters, and legal scholars crowded the steps, discussing what they had just witnessed. Analysts declared it one of the most remarkable Supreme Court performances in decades. Newspapers ran headlines praising Crockett's skill and Justice Breyer's unprecedented recognition. Legal scholars across the political spectrum hailed the presentation as a model of constitutional advocacy. 3 weeks later, Justice Breyer announced his retirement. In interviews, he reflected on the argument, noting how one moment of exceptional advocacy could illuminate constitutional principles in a transformative way. 2 months later, the Supreme Court issued its ruling in Johnson v. Texas Election Commission. In a 6-3 decision, the court struck down the law. Justice Breyer authored the majority opinion, establishing a new framework for evaluating discriminatory intent. Courts were instructed to look beyond neutral language to evidence of awareness, intent, and the sequence of events surrounding legislation. Voting rights advocates immediately used the ruling to challenge similar laws in other states. Polling places were restored in previously affected Texas communities, and voter turnout surged by 37% in those areas. 6 months later, Crockett delivered the keynote at the American Bar Association annual meeting. She told law students and lawyers, constitutional promises aren't self-executing. They require preparation, mastery of details, and unwavering focus on principles. The most powerful tool isn't rhetoric, it's preparation, evidence, and clarity. Justice Breyer, in his final interview before retirement, reflected on the case as a defining moment in his career. Sometimes a single argument can illuminate constitutional principles in ways that reshape the law itself. In the years that followed, states reconsidered policies that had restricted voting access for minority, elderly, and disabled citizens. Participation increased, the democratic process became more inclusive, and law schools taught the case as a blueprint for exceptional advocacy. For Crockett, it became a defining achievement and a platform to continue defending constitutional rights, economic justice, and fair representation, grounded always in service to the citizens whose voices her work amplified. The story of that courtroom remains a lesson in preparation, moral clarity, and the enduring power of one determined advocate to uphold the principles on which the United States was founded.